Okay, welcome to our webinar, our scheduled webinar. I've just been asked to give a bit of a disclaimer. There may be some background noise. We have some construction work going on next door. About 30 minutes before we started recording, they brought out the heavy roller, but it stopped. Seems to have stopped now. It may come back, but you know, if it does, it shouldn't be too disruptive. Just to give an introduction about who we are the business immigration team. This is Sally McEwen, who is our director and senior lawyer. We've got Lydia, who is a senior lawyer, and I am a trainee solicitor. We're also supported by Caitlin, who is our paralegal, who's not joining us today. But if you do have any follow-up questions and you want to speak with us, it will be one of the three of us that you speak with. Today, we are going to cover changes to the sponsor license guidance. We're mostly going to be covering changes that apply to sponsors of skilled workers and global business mobility workers. And if you look at the guidance yourself, you will see that it is mostly, it is a long reams and reams of changes. Most of these are minor drafting amendments. We're not going to cover all of those because we will bore you to tears, and most of them just don't really apply. So one of the big changes we've seen is that the salary thresholds for all roles have been reviewed and updated. So this isn't just the main thresholds, these are all of the specific thresholds that apply to each individual occupation code. These, if you want to have a look at them, they are all set out in Appendix Skilled Occupation. And the other important update is that the annual salaries are now calculated on a 37.5-hour work week. So those with sponsor licenses already, you'll remember that it was previously calculated on a 39-hour work week. So this has the impact of having quite a significant increase in the salaries themselves. I'm going to hand over to Lydia to talk to us a little bit more about the salary threshold increases. Lydia, we call these kind of floor rates, base rates, threshold rates. It all means the same thing. Can you just talk to us a bit about how much these have increased?
Yeah, sure. So as Sam said, when you're looking at how much you have to pay a skilled worker, you've got to look in a couple of different places. You need to look at the going rate that's set out in Appendix Skilled Occupations, but you also need to look at what the Home Office called the threshold rate of pay. I tend to think of it as a floor as to what you can pay any worker on the skilled worker route. You need to look at both of those and pay whichever one is higher. So the general minimum, which is the one that probably the majority of skilled workers will be on, option A, that's gone up to £26,200. Option B has gone up to £23,580. So that's the option for workers who have a PhD in a relevant subject. And then all of the other options, C, D, E, and F, the minimum threshold for those has gone up to £20,960. In addition, if you've done this before, you'll realise that you also need to look at the hourly rate that you're paying workers. And this applies across the board. You must never be paying a skilled worker less than this amount. Previously, that was £10.10 an hour. That has now gone up to £10.75 an hour for new hires.
So these changes, they came in on the 13th of April. We know that the Home Office and businesses themselves, they don't always work to the same schedule. And equally, the process of hiring a skilled worker can take some time. Yeah. We often have clients who assign the certificate of sponsorship, and then it takes a little bit of time for these skilled workers themselves to apply for the visa. In the situations where somebody has assigned the certificate of sponsorship before the changes came into force, and so they assigned it based on the previous salary rates, but the applicants haven't yet submitted their skilled worker visa, which are the rules that apply to those businesses?
Okay, that's a good question. So if you have assigned a certificate of sponsorship to a worker and the date that you assigned that certificate was before the 12th of April, then the old rates apply under the old rules. If you assign a certificate of sponsorship from the 12th of April onwards, then you will need to make sure that you are meeting the minimum for the new higher rates. The other thing I'll say is that these are rates run from the date that you from the date that you sign a certificate of sponsorship. So if you have existing employees on the lower rates, they can potentially stay on those rates for now, but any new certificates of sponsorship that you assign must meet the higher rates.
So expanding a little bit on that kind of minimum pay threshold, we know that there are some wider requirements that aren't necessarily set out clearly. Where are the situations where applications for a work visa or a defined cause might be refused in this respect?
So the immigration rules, the recent changes coming in on the 12th of April have introduced another couple of, or some clarifications, I guess, on grounds on which a defined certificate of sponsorship could be refused. In particular, they've now clarified that a defined certificate of sponsorship may be refused if the caseworker thinks that it would not meet the requirements of the national minimum wage regulations, or if it would not meet the requirements of the working time regulations.
And generally speaking, the rates that are advertised for businesses, so well, not so much advertised for business, but the rates that are advertised for the occupation codes that are eligible for this visa, those are normally much higher than the minimum wage. So where is it that these new requirements or these clarified requirements would apply to businesses?
Yeah, I agree. It's a bit of a puzzler in that you're right. The minimum rates that you have to pay all skilled workers are usually significantly above the national minimum wage. It's not something I've got immediate experience of coming across myself, but the fact that they've changed the rules to account for it does tend to suggest that it's been an issue that the Home Office have come across themselves. Some possible issues could have been, for example, if employers are making deductions from salary. For example, if you're making deductions from salary for to cover rent payments, that can sometimes have an effect on the national minimum wage. Or if they are concerned about how employers are calculating working time. So, for example, if employers are not including time for travel between assignments, that could potentially be an issue. Also, obviously, if employers are assigning certificates which just have a very high number of weekly hours, that may indicate breach of the working time regulations.
Okay, and the one of the things that's always important to remember with dealing with businesses and regulations is that not every business fits into a box. Every business has their own way of working, and while we calculate these salaries on a 37.5-hour work week, in some cases, though, people have working patterns that fall outside of a straightforward, this is how many hours you work per week. We generally call these irregular shift patterns. Can you define that a bit more clearly for us?
Yeah, so this is again another change that's been introduced to the rules in this round of changes. It is quite complicated. The good news is that if you are a business that does not operate in a regular shift pattern, then it's not something that you need to worry about. So if your workers just work 9 to 5, Monday to Friday, this doesn't need to worry you too much. But there are other sectors in particular who will operate an irregular shift pattern, for example, a compressed working pattern where workers might work a large number of hours for 1 or 2 weeks and then have a full week off. I've seen offshore workers doing that. I've also seen that applied for live-in staff, for example, in the care sector. So in those cases, the Home Office have introduced some kind of exceptions to make those working patterns fit within the immigration rules. I was talking earlier about the absolute minimum threshold rates that you have to pay for the different options. For those, you can only include hours up to a maximum of 48 hours per week, usually. Any hours over 48 per week are not counted towards the salary to meet the threshold. However, where you're operating an irregular shift pattern, work in excess of 48 hours in some weeks can be considered towards the salary threshold, provided that the average over a regular shift cycle is not more than 48 hours per week. So essentially you can average it out. And that shift cycle pattern can't go on for longer than 17 weeks. Any unpaid rest weeks will count towards the average when considering whether the salary threshold is met. And any unpaid rest weeks will not count as absences from employment for the purpose of Part 9 of the immigration rules.
And just to expand that slightly further, can you clarify what Part 9 is? Because this is something that comes up often in our day-to-day work, but many times I will say Part 9 applies to a client and they will look at me with a blank face.
Yeah, sure. So Part 9 of the immigration rules covers what's called the general grounds for refusal. It contains all of the reasons that the Home Office could potentially refuse lots of different types of visas or cancel them. In particular, in respect to this, usually the Home Office will cancel the leave of a skilled worker if it's reported that they've been absent without pay for 4 weeks or more in a 12-month period. Now, obviously, if you've had unpaid rest weeks and they were counting those as weeks absent without pay, then you would end up curtailing your workers' leave on a very regular basis. That would be a problem. So where you're operating one of these irregular shift patterns, those rest weeks don't count as weeks of absence for the purposes of Part 9.
Brilliant. And this specific area is quite complex in terms of the amount of information that we've just given to people. Can you put this into a bit of context for us, and can you give us a case study to show us what that means in practice?
Yeah, okay. So happily, the Home Office have set out their own example within the guidance, so I will rely on that one. So the example they give is you might have an applicant who works a work pattern of 60 hours a week for 2 weeks at £12 an hour, followed by an unpaid rest week. So when they're looking at that, the Home Office will consider the applicant to have worked 40 hours a week on average over the 3 weeks. And if they're earning £12 an hour based on a 40-hour working week, that gives an annual salary of £24,960. So that would not be sufficient to meet the threshold for option A, but it would be high enough to meet the threshold for the other options, B to F.
Thank you. I'm going to jump over to Sally now, because we talked a little bit about unpaid rest weeks, but unpaid leave in general is a fairly important area. Sally, can you expand a bit further on what the changes are to how unpaid leave is handled and what a sponsor's responsibilities are when it comes to that leave?
So the Home Office have updated the guidance to clarify what a sponsor must do when an employee has unpaid leave or is on reduced pay for a period of 4 working weeks. Now, there are exemptions to this, which I think we're going to go through shortly, but the basic rule is you always have to report these unpaid absences to the Home Office or report the reduced pay.
And just to be really clear, that 4-week period, is that a cumulative 4-week period or is that a non-cumulative period?
So it is a cumulative period. So the 4 weeks can be in one period, or it can be cumulative over the 12-month period. It's also important to remember that the 4 weeks is calculated on a worker's normal working pattern. So if you have somebody working for a 5-day week, then that 4-week period is 20 days. If they have a 3-day working week, it is 12 days.
And if the employee goes over that limit, what are we talked about reporting it, yeah. But what does that mean in terms of the sponsorship?
So in terms of the sponsorship, it means that a report will be made on the system and that employee's leave will be curtailed.
Okay, and you've mentioned exceptions to this. Can you expand on those? Well, firstly, can you explain to us what the Home Office will do when you give them an exceptional or compelling reason?
Exceptional or compelling circumstances can arise where you have an employee that's gone on unpaid leave for more than 4 weeks. And the sort of classic example of this is on bereavement. So you might have a bereaved employee that's returned to their country of nationality, to attend to, kind of funeral arrangements and that kind of thing. I think that would probably be classed as a compelling or exceptional circumstance. It still needs reporting, and the Home Office will decide whether or not the reason that you've provided is compelling or exceptional. If they decide that it is not compelling or exceptional, then they themselves will curtail the leave of your employee.
And so you've given us one example there being bereavement. Are there any defined exemptions?
There are defined exemptions, so maternity leave, parental leave, adoption leave, sick leave, helping in an international humanitarian crisis, attending court to give witness evidence, or jury service, although jury service would be unusual for a sponsored worker because they are not on the electoral register. I think those are the main exceptions.
And while we're on the topic of exemptions, there have always been reasons that an employer is permitted to reduce pay, normally in a temporary basis. Can you tell us about how this has been expanded in the new guidance?
So yeah, the guidance has been expanded to include reduced pay where somebody is returning on a phased return to work, and that will be usually after a period of illness or sickness. So that can be reported, and that's accepted if on a phased return to work. But you must meet the requirements for the new rules, which is to provide an occupational health assessment, and also that the hourly rate must not fall below the minimum hourly rate for the standard occupational classification code that was assigned when the certificate was assigned to the employee.
Okay, so I'm going to now jump onto an entirely new topic, but this is one that I think people are going to be absolutely delighted about. So we all know that the immigration skills charge can be a very costly process for businesses to go through, and that in some cases this can be a major barrier to hiring sponsored workers. We've previously seen exemptions to the skills charge in terms of new entrants, so people who are hired coming straight out of university, and in a few other circumstances. We have some new exemptions to that. Can you tell us about those?
We do have some new exemptions, and this is really for the senior and specialist workers under the global mobility route. So provided all of the following requirements are met, then you will be exempt from paying the immigration skills charge for the specialist worker route. If so, you need to have assigned the certificate on or after the 1st of January of this year. The worker needs to be a national of an EU country. The worker has been assigned to the UK by a business established in the EU, which forms part of the same sponsor group as defined in the sponsor global business mobility worker. And the certificate of sponsorship is no more than 3 years from the start date. When you apply for your sponsor license with a global business mobility visa, you will need to set out and confirm all of the linked entities wherever they are, and they will then appear in your sponsor management system. So the entity needs to be linked in the sponsor management system for you to be able to benefit from this exemption. Yeah, that's basically it.
And is this exemption applied globally? Does this apply to workers from all over the world, or are there any limitations?
No, there are limitations. So the business must have been established in the EU, and the concession does not apply to those EEA countries: Iceland, Norway, Liechtenstein, or Switzerland. Okay,
and while we're on the topic of the immigration skills charge, one of the common questions that we get and that we deal with a lot in terms of inquiries is, what are the costs that businesses can pass on to their employees? And it's always been the case that businesses are able to pass on costs related to the visa application itself to employees, but must not pass on the costs related to the sponsor license, such as the skills charge, to them in place, because those are the costs that your business must bear. We've seen some changes in terms of the guidance and the consequences of doing that. Can you just give us a brief overview of those changes?
Yeah, so the Home Office have never really clarified what would happen if a business passed on the immigration skills charge to an employee. We have always been quite clear that the immigration skills charge and the certificate assignment fee of £199, they are costs that must be borne by the business and not be passed on to the employee. I suspect that the Home Office have received some intelligence now that this has been happening, and have introduced into the guidance consequences for passing on that immigration skills charge to your employees, and the consequences are significant. So if you have passed on skills charges to your employees, your licence could be revoked.
Okay, and I think really the last kind of major changes we want to talk about are, they come across as quite small changes, so that they're ones that we can jump through quite quickly, but they're going to be changes that businesses are very happy about. Those of our business viewers who are working in the tech sector, you might call these quality of life changes. Can you talk to us about those?
Yeah, so these are the beneficial changes that the Home Office have made. So sponsors will be aware that when you make certain reports on the sponsor management system, it could take the Home Office up to 18 weeks to reflect those changes in the system itself. Some of those changes would be eligible for a priority service if you could pay £200 and were lucky enough to secure one of these 60 slots per day that are issued at 9 AM. But the changes that the Home Office have made mean that some of these applications now will be reflected in the sponsor management system straight away. So if you add a level 1 user, provided that level 1 user is either a representative who is named on your licence and the postcode for that level 1 user is the same as the representatives, or you're appointing a new level 1 user that is employed and they're employed at the same postcode as the licence, then those changes will be reflected immediately. If you're changing your authorising officer, again, the postcode of the authorising officer needs to be the same as the one for the registered business on the licence. That's a change that is reflected immediately, and if you change your key contact, that is another change that is reflected immediately. These changes are still required to be supported by submission of the submission sheet. So those of you who are familiar with some of these changes, you'll know that there is an option to print the submission sheet when you've changed the made the changes to the licence, and then you send that on to the sponsor change of circumstances email.
And in terms of COS renewal, we've seen some changes in that respect as well.
So yeah, again, this is another quite positive change. You will be aware, those of you who are sponsors, you have a year-in allocation of undefined certificates that can be assigned to workers who are already in the UK and require sponsorship. Rather than kind of looking into your crystal ball for the next year's COS allocation, the Home Office will now automatically issue you the same number of certificates that you used in the previous allocation year. Now, your allocation year, if you're an older sponsor, will be the same as the financial year, April, and if you are a newer sponsor, then the allocation year starts on the date that your licence was granted. If you don't use any certificates, undefined certificates during your allocation year, then you won't get any for the next year, but you will still be able to make an ad hoc request for an increase in the same way that you can at the moment, either if you run out or if you're not granted any at all in the year. But again, that's one of those applications that you make through the sponsor management system that takes 16 to 18 weeks for the Home Office to decide unless you secure that priority service. But overall, it's a pretty positive change. You don't have to remember to apply for your year-in allocation, provided you used some of those certificates in your previous allocation year.
Brilliant. Thank you very much, and thank you both of you for your insight. It was really a whistle-stop tour in terms of the key changes to the guidance. I'm going to just give a bit of a wrap up. What I will say is we're about to do a bit of a Q&A. So we are going to take some questions that are coming through to us. We've had a few questions through already, but just to give a few more time to trickle in, please do let us know if you have anything you'd like to ask. We always do our best to answer every question that we have. That's not always possible. And the reason being is sometimes the questions are very specific or very detailed in a way that we just can't cover here. So if you're providing your your contact details. And when I say contact details, just your name is fine. And we're not able to take your question, we're not ignoring you. We will contact you afterwards. Similarly, I would just encourage everybody to be a little bit careful about what you do put in the Q&A. Don't put anything too identifiable about your business, because we obviously can't give absolutely direct legal advice without speaking to you in more detail. Just while those are coming through, to let you know that as you've attended this webinar, we will be sending out follow-ups. So you're going to get priority access to the video, which will go online. So you'll get that through a little bit earlier than when it goes public. You also get a set of slides, which we've not used today because we wanted to do this in a bit more of an informal way than we have done in the past. But we have prepared a set of slides that you'll receive that contains the key information that we've discussed. We've also got a blog article that is going to go live as well that covers the key information. If you've got any specific questions that you don't want to ask today, we do offer a free consultation service. So if you're an existing client, then I'd encourage you to contact whichever of the three of us represents you. And if you're new to us, then by all means book one of our kind of free 30-minute consultations and we'll have a chat with you. And again, we are the team, so it will be one of the three of us that you've seen today that you speak to. So in terms of the questions that we've got through so far, if I look like I'm hunched over slightly, there's a bit of a reflection, so I apologise for that. But the kind of first question we've got relates to hybrid and remote working for sponsored workers. Someone's mentioned that they have heard that they are now required to update the Home Office about sponsored workers, hybrid working and work from home arrangements. That's largely always been the case. Can I speak to just really specifically what are the requirements in terms of reporting where an employee is working?
I think we always encourage our clients who operate this hybrid system of working to add an alternative work address to that employee certificate. So you will have somebody who is based in the office sometimes and then based at home sometimes, and you would have that alternative work address. The Home Office still, I think, are not 100% comfortable with complete remote working, because actually, and that makes sense, because why would you need to sponsor somebody who can work completely remotely? With today's technology, you can work anywhere, so that person wouldn't necessarily have to be in this country if they were working completely remotely, unless it was for site visits and things. So we would just say just to report that alternative work address on the sponsor management system for somebody who's operating on this kind of hybrid working.
Okay. We've had a question that I want to throw to Lydia because it relates to what you were talking about, the floor rates. I'm not going to rephrase the question in the exact way it's been sent to us because it is quite specific, but I think the core question is around these minimums. So we've listed a number of minimums. We've listed the overall floor rate, we've listed the hourly rate, and we've listed the general salary rate that applies to that occupation code. Yeah. So those are the three different minimum salaries we have. What happens if somebody can meet one of those requirements but doesn't meet one of the others? For example, maybe they meet the minimum hourly rate, but they don't meet the rate for their occupation code.
Okay, so what you've got to do is you've almost got to look in three places. You need to look at the going rate, you need to look at the threshold rate, the floor, and the hourly rate. You need to pay whichever one is highest. What that means is that when you look at the Home Office website, it looks as if you can sponsor someone. Previously it was about £25,000, now it's the increased rate, £26,200. But actually, there are lots of workers that you can't sponsor at that rate. The going rates are designed to prevent skilled workers being used essentially to undercut the resident labour market. So where the market rate for the job that you're sponsoring has a higher minimum salary than that minimum threshold, you need to pay the higher rate. Okay.
I'm going to jump back to Sally because this is a question about one of the things we spoke about fairly late in the conversation. We talked about the immigration skills charge and COS charges and how those cannot be passed on to the employee. What happens if somebody wasn't aware of this and that they've charged their employees?
Okay, so just I would pay your employee back if they have paid you already. I mean, it's quite a difficult question to answer on the webinar because I don't know how it's come about that you have charged your employee for that skills charge. I don't know whether it's subject to some kind of clawback agreement or it's probably sensible if we have a separate discussion about the circumstances in which this has happened and then speak about how we can rectify that.
Yeah, and to the person who's asked us that, we've not got your contact details, so you don't need to provide them on the webinar, but by all means, please do give us an email and we'll be happy to speak with you. This is another question that I kind of say to this individual, if you would like to contact us, please do, but we'll try and cover it a little bit. It doesn't, strictly speaking, relate to the guidance changes, but it is something that we've touched on very, very briefly, and it may be useful just to cover for those who are watching, because it's something that comes up fairly commonly. In terms of healthcare workers, so I think, Lydia, this was something you mentioned very briefly about irregular shift patterns. So there are circumstances, for example, in the healthcare sector where people are live-in workers. The question we've got is that their understanding was that live-in was not allowed on healthcare worker visas. Really, this kind of comes back to what your observation and monitoring requirements are as a sponsor. If you need specific advice on this, this is something we would need to discuss with you as a business, because it varies depending on what the business is. But can you talk just broadly about what the requirements are for monitoring?
So for monitoring remote workers?
Yes.
So at the end of the day, you need to have a fair degree of idea of where your employees are and what they're doing when they're working for you. So for example, you need to be able to report to the Home Office if they just go AWOL for 10 days, for example. The other thing is, at all times, you have to sort of have a degree of control over the duties of your worker. So what the Home Office really don't like is if you sponsor someone and then sort of seek to send them on an almost permanent consultancy basis to a third party, and really, in effect, they're being employed by that third party. You know, the third party is determining what hours they work, the third party is determining when they can take their annual leave, those sorts of things. So I think that would be the other key thing in that situation, is that you as the sponsor must be their employer, be undertaking those employment duties, and determining, you know, what they do and when they work, those sorts of things.
Okay.
There's a couple of sectors actually that this is relevant in. So in the kind of construction as well, where you have a sponsored construction worker and then you send them out to work on a construction site. This is obviously made me think of it because it's going on next door, although it's not that noisy at the moment. But you know, your worker would then be told what to do by the foreman on the construction site and not necessarily the employer. So yeah, Lydia's absolutely right. You need to demonstrate that you have effective control over that worker's duties and what they're doing.
IT is another classic that the Home Office often get quite worried about.
So we've got a question about the minimum. The question is around where that doesn't necessarily, when I say minimum, I mean the minimum hours per week that an employee works. So there's questions around where somebody doesn't work, the shift patterns don't fit to what the Home Office calculate their salaries on. So we've covered that the Home Office salary calculations are based on a 37.5 hour work week. What would happen if somebody worked 35 hours in 1 week, 45 the next? The question is around how you do that pay. This really comes back to the irregular shift patterns question.
It does to
Yeah.
an extent. I'm not entirely sure that the change to the rules on the irregular shift pattern necessarily would apply here.
Mm-hmm.
I think I would say that we really would need to have a look at it and advise you directly as to, it may be that the irregular shift pattern, the changes to the rules around the irregular shift pattern may assist you. But I think we need to really look at the details of how you're working that out and get some more information about it in order to provide a meaningful answer, I'm afraid.
Okay. We've got a kind of general question which I can pick up a little bit here on sponsor license applications in a more broad sense. And that is, how long does a sponsor license application take? I think really the answer to that question is how long is a piece of string? Because we can give a fairly straightforward answer in terms of processing. So the processing of a sponsor license application is advertised as 8 weeks. We generally find that decisions are received within that time frame. You can also apply for what is called the priority service, which is an additional £500 to the business, and that's charged by the Home Office. And this means that the decision is made, I believe it's within 5 working days, isn't it? 10 working days from the date that you pay that fee. It's important to note that that is a lottery system, and it requires contacting the Home Office and requesting a priority slot at 9 a.m. each day until you get a slot. So there's no guarantee you can get it, but it is there as an option. In terms of the application more broadly, so preparing an application, that's where it becomes a lot harder to give a straightforward answer. And really, that is going to depend on the access you have to the required documents, how complicated it is in terms of your business. There's a bit of a follow-up here, which is about kind of pre-revenue startup companies, basically businesses that have just established and not yet trading. Really, we're not going to jump into that in too much detail here. I would encourage that business to reach out to us, and we will have a consultation with you, and we'll discuss your specific business, because it can vary from sector to sector. It really depends what your business is doing and what you have in place already. But generally speaking, the earlier you are in your business's lifespan, the harder it can be, because you need to satisfy the business.
Yes and no. I mean, there's certainly there's no kind of bar on a new business being able to sponsor workers, and we have worked with a number of startup companies who have been able to secure the sponsor licenses and get people that they wanted into the UK. But the kind of evidentiary requirements for a new business would be slightly different than a business that's more established. So there's not a kind of minimum revenue threshold you would have to show for a new business, but we'd need to speak to you about the nature of the business and the sort of documents that you are able to get to demonstrate that the business is genuine and that you have genuine employment opportunities.
Yeah. And that is all of the questions we've had through. I would note that there's a couple that I've not answered. To those watching, I'm not ignoring you. They just fall a little bit far beyond the scope of what we're talking about today. But I've made a note of those who've asked, and we'll get in touch just to provide an answer to those questions. But yeah, I think that goes back to thank you very much for joining us today. I'm just going to restate what we'd already said for those who might not have caught it. So we're going to follow up by sending the priority access link to the video. We're going to send copies of the slides, which we've prepared, but we've not shown today. And equally, there will be a blog article. For those with an interest in having a deeper discussion with us, if you're an existing client, please get in touch with whichever of us you deal with most commonly. And for those who are new to us, please by all means book in with a free consultation, and we will be happy to speak with you. Just want to obviously thank Sally and Lydia for their expertise today, and a big thanks to our ops team as well. Marcus, who's not in here with us today, he's next door, and Hannah, who's sat behind the camera at the moment, who have put a lot of work into getting this up and running, and has largely meant that we've just been able to sit down and show up. So a big thank you to them, and of course thank you to everyone who's watching.